Good evening, everyone, and we're very glad to welcome you to the Legal Writing webinar series, Webinars and Practices 2021-25. We're extremely happy to kick off this webinar series, which is the continuation of a huge project that we have been running starting from 2022. And I'm very glad to welcome you and to announce that we are going to have 6 webinars, which will take place every 2 weeks on Wednesdays this time. And I would like to also introduce our wonderful specialist, whose name is Heather Weger, Dr. Heather Weger, who is going to be the star of this series. And Heather, we welcome you to our series.
Thank you, Sophia. It is a delight to be with you all and to be prepared to talk with you over the next 6 sessions about what it means to do legal writing through the lens of legal English. I'd like to start today just by giving you a little information about who I am. And first of all, I am a professional working mother. So these are my 2 kiddos that take up quite a bit of my mental space and time and energy. But in addition to being a mom to these 2 great kids, I am a linguist, not a lawyer, but a linguist. And that makes me uniquely positioned to talk with you today and over the next 6 weeks, or 6 sessions, about the principles of legal writing in English. So I come to you as a linguist, which means I bring a passion for how language functions in accomplishing its communicative goals. And in particular, I have the skill set to decode what legal English is and how it is working in a particular space. And the way I'm going to share these insights with you today is by walking you through a couple of activities. The first is that we're going to explore what we mean by the chicken and the egg as a way of understanding the relationship of legal writers to readers. We're also going to take a look at genre analysis as a tool that can help us understand what the foundational principles of legal texts are. And then I'm going to tap into your intuition. You are legal experts, and we're going to call on that intuition to examine excerpts from different legal English text types. We will be taking a look at some text types from these different sources, and at the end of the slideshow, I will have excerpts from all of those sources cited so that you can read them in a larger context if you wish. And the takeaway point for us here is that we want to make sure in this first foundational session that we examine the relationship between the reader and the writer, which allows us to understand what the expected features are for a particular text. And of course, in our circumstances, we're going to take a look at how it works in legal English text in a U.S. situation. So let me start with the writer. And you may be curious about why I'm going to start with the reader when we are talking about the writer. And that is because well-established legal writing experts recognize the impact that the reader has on the role of their writing. So I'm going to give you 2 quotes from these legal experts in the field of U.S. writing. The first is an academic who has written several textbooks on legal writing. His name is Newman. And this quote is that legal writing must be designed so that it can be easily digested by the reader. And that cannot happen without good organization. This sentiment of the impact of the reader on the writing process is emphasized by Justice Ginsburg, and she speaks about her ability to write as keeping her eye on the reader. And in doing so, she tries to write as clearly and concisely as she can. So now that we have taken a look at these quotes, what I want to express to you is an emphasis on how relying on the reader or focusing on the reader means that you are writing in an organized manner that is clear and concise. In fact, here in the U.S., legal writing is often labeled as a reading-centered versus writing-centered language. But ultimately, I think this means that all writers in all language systems are actually focused on the reader because all writers are trying to meet reader expectations. Let's take a moment here in the chat box. I'm going to put Sophia to work a bit. I'm going to give you a quick question to think about, and I want you to choose one of them. And I'd like to have you type into the chat box 1 or 2 sentences for your reaction to these questions. So the first question is, if you have heard the terms reader-based or writer-based, which system do you think legal writing in your context follows? And the second question that you can choose is, you are experienced legal writers yourself, and what role does the reader play for you? And the final question is, when I talk about things being organized or being clear and concise, what does that mean to you? So let's just take one moment, choose one of the questions, and share one of your thoughts with us.
Mm-hmm. Okay, dear all, and I wanted to say while you are thinking that there are several options how you can answer the questions. Option number 1 is, of course, we send you a link to Telegram, our channel, or chat, where you can write the answers from Heather, Dr. Weger. The second option, you can write it in comments to YouTube, our stream, and also you can submit your comments VKontakte, also as comments to the video. So there are 3 options you have, and we would really like to hear from you. So Weger, dear Heather, I need to look through 3 different places, but we'll figure it out. So, and I will be very, very happy if you can write some of your thoughts. So, and while you are thinking, I wanted to also say that we have a unique program right now, because for the first time we're introducing a practical session, which will be an addition to the theoretical part. And Heather also created a great program for you, which will basically take you along the road of of the process of becoming an experienced legal writer. And we'll start with the beginning. So what are the basics of legal writing, how then you are going to get strong, and how to become a mature one. Of course, we are limited in our time and in the number of classes, but you will get an overview of our major principles which differentiate a writer from a legal writer, and secondly are the major principles of our legal writers to American law. And that is very interesting because it is very, very different from Russian writers. So I think I gave some time to come up with some ideas. So, and there we are. So
Sophia, for giving a shout out to our second component, our more practice-based component of our series.
Mm-hmm.
And the focus for me here, as we wait for those last few comments to get posted or for you to think about your reactions to these questions, is that what we're doing in this theoretical space is only valid in the sense that it resonates with you on a personal space. So this is a chance to hear and think about how these concepts resonate with you as a writer. So Sophia, was anyone brave enough to share a thought with us?
Yes, absolutely correct. Yes, there are some of our viewers who are right now typing in. And we're speaking about question number 1. Right now in Russia, legal design is very popular. So we're trying to be understandable for readers. So in Russia, there is a concept of legal design. So basically, what you have called over here, reader-based. So creating or organizing your writing so it is convenient for the reader to read and to understand. So
thank you for sharing that.
Mm-hmm. And also our Daria has answered question number 3. Thank you very much, Daria. That clear and concise means to me that you do not overwhelm the reader with a lot of information and include only the necessary information into the text.
Mm-hmm. 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 And that distilling of what is necessary is, of course, context dependent. And what's inspiring to me about these comments is that it indicates that we are actually in a shared space of understanding how written texts are intended to work in particular legal communities. So what I want to think about here is to take this one step further and help you understand why the series is beginning with the reader. And that is going to make a little bit more sense as we go through this next slide. And I'm going to use the idea of the chicken and the egg. Which came first, the chicken or the eggs? For us, in our reader-writer conversation, what we want to think about is, did the writer create expectations for what makes text successful? Or did the community of readers build up that set of expectations that then writers began to follow? If we think about this relationship, what it reveals is that when we keep our reader in mind, it really just means that we're being aware of what our reader is expecting, and then we're writing in a way that meets those expectations. So really, this reader-based, writer-based, reader-focused, writer-focused is a somewhat of a false dichotomy, because all writers in all languages, in all professional circles, are reader-based, but what readers are expecting differs. It differs across place and product, so it differs depending on where you are, what community you're in, and it also depends on what you're trying to produce, the text type. So this leads us to sort of think about where do these reader expectations arise from? And fundamentally, it is from multiple exposures to written texts from a particular text type. So the actual texts do not need to be identical, but given enough examples, similarities from the text become sort of normalized and expected for the community. So in short, it's expectations for both the reader and the writer arise over time, and they represent a tradition of use, a tradition of exposure within a particular community. So the shared expectations, the shared similarities within a particular text type are the features that distinguish one text type from another. And this distinguishing feature is what the concept of genre attempts to capture. So we are really ready now to take a deeper look at what we mean by genre in the context of, not the law yet, but movies. I'm trying to keep everyone out there awake. And Sophia, be prepared. I have a quiz for you coming up, okay?
Okay.
All right. So I am using genre as a tool. And it's a tool to help us understand what these foundational writing principles for legal writing and legal English look like. We're going to practice now with movies. Sophia, I'm going to try to stump you, okay? Only one of these is correct. Only one of these descriptions of the genre of a particular movie fits the image. Sophia, can you tell us which one is the correct answer?
Yes, the correct answer is Western.
Let's see if she is correct. So here's a comedy. Here's detective. Here we go with our drama. And also, finally, the Western one. So, Sophia, you have passed my test. Right? The reason that Sophia can pass the test is because she is a moviegoer. She is a part of that movie community. And you, as a member of a community of moviegoers, know what the expectations are for particular types of movies. And so, when you look at the type of movie, it has particular shared features that you associate with that particular genre. Now, what we're going to do is put this into the context of legal writing. My working definition here of genre for legal writing is it's really a means of understanding the shared features of text types for particular discourse communities. Here we do mean the legal community. For the purposes of examining legal English, I'm going to focus on 3 shared features today. I labeled these logic features, organization features, and language features, okay? Before we take a deeper look at them, I'm sorry, I want to back up for a moment. Before we take a deep look at these 3 categories, I do want to talk a moment about what the terms are representing, because the terms are all abstract. If I show you my coffee cup, right, and I say the word cup, it's a concrete object, and we sort of know what a cup might look like, even though it can have variations, right? It becomes a little more difficult when what we're trying to capture is an abstract category. It's not something that you can hold in your hand. Words like happiness or sadness, right? Those are abstract concepts. So I have chosen these 3 terms to represent abstract concepts. And we use the linguistic concept of indexicality to unpack these terms that I'm hoping to represent. Indexicality is merely a word that shows that meaning is built up over time and use. So a word like cup indexes, it connects to the summation of all the different exposures that you have personally had to things that we label as cup. Cup. You can't really see that one. Cup. There we go. That was better. And meaning can grow, it can change as you gain more experience with the different ways that society is using that item. Okay? So we're going to start with what do we mean by the logic features of a legal community's text type that's different from what do we mean by organization features or what do we mean by language features. So when I talk about the logic features, I am talking about what does the text do? What is the purpose of the text for a particular set of readers? What do the readers count as logic? What do they accept as being evidence of logic in that particular situation? And trust me, different communities have different understandings of what counts as logic. You can just spend a few minutes with my children and you will understand that. So what I would like to do is go over these 5 different text types, and there are more legal text types, but I'm just going to present you with these 5 today to demonstrate what I mean by the logic features. If we look at the law review article, we'll see I'm drawing out 2 points. One of the points is who, the audience, and the second point is the what it's doing, the logic, the purpose. So the law review article, as our first example, it is written for a general legal audience, and the writer's purpose is to persuade the legal readers to accept the author's legal position. We often refer to this legal position as the thesis of the text. And a law review article is something that not only lawyers might read, but other professionals in the field. And it's intended, unless the journal is discipline specific, it's intended to be read by those who may or may not have domain specific knowledge. And that's what I mean by it's written for a general legal audience. If we take a look at a contract in contrast, this is written for parties who are entering an agreement. And here the writer's purpose is not to persuade, but to record. So the writer is recording details of an agreement. It's outlining rights and responsibilities of the different parties in the contract. If we shift to the office memorandum, or memo for short, it is written for practitioners. In the post-school education, post-education world, it's a document that you might produce for a legal firm, and it's for lawyers within that same firm. And of course, this is going to introduce its own variations because memos in one firm are going to follow the conditions and expectations of that firm, which might not be the same as other firms. But office memos are often commonly taught at the university level to prepare practitioners, right? Those who are going to go into the actual law field. And these memos are have as a purpose predicting how a court is going to rule in certain conditions. So this often actually trips writers up who try to persuade with a memo, but a memo is not persuading, it is predicting. It's saying we've taken a look at all of the law, and this is what our outcome is that we think will happen if we were to proceed to court, right? Then we'll contrast that with the appellate brief. The appellate brief is actually persuasive. This is written for judges, so by lawyers for judges. And the writer's purpose is to persuade the court to actually reach a particular decision. So this is sometimes referred to as advocacy work, because you are advocating on behalf of a particular client in a particular situation. And the last category I have for us to look at today is the court decision. This is another lawyer-written document, and it is written for the law community, and it is also written for the public domain. Legal records are public domain in the U.S., so anyone can access them and read them. The writer's purpose, that is, the writer being the judge's purpose is to explain or justify the rationale that the court has used to reach the decision that it has reached. And it has a second focus, which is to actually declare, to stipulate what the law is, what the decision is in a particular case. So we are going to test your intuition about these areas here in just a moment. And I'm going to ask you to look at what samples from some of these categories and see if you can match the sample to the type of text that it has. So I'm putting back up all of the categories for you to see. So you can take a moment to grab a snapshot if you want to pull your cameras out. I'm sure you all have yours sitting right next to you, right? If you want to have a cheat sheet, if you want to have something to look back as you take my little quiz, all right? All right, so in this quiz, there are going to be two texts, and I'm going to see if you can match them based on your intuition to the text type, to the genre. All right, here we go. Sophia, you can take the test mentally, all right? Mm-hmm. Our first excerpt, based on your intuition, what type of legal text, that means the legal genre, does this paragraph come from? And if you want, you can share your answer in the chat box or through the other mechanisms that Sophia has mentioned. Don't worry, I'm not going to call anyone out this time. Just gives you a chance to show your prediction of your answer. Okay, here we go. This first paragraph is coming from a scenario that involves a completely fictitious country called Urbania. Okay, Urbania does not exist. It is made up. Now, the paragraph does exist. I took it from a textbook, and I'll share that reference with you guys at the end of our session. But Urbania is a pretend country, and in this scenario, they are considering something with their bondholders, something about their relationship to their bondholders. All right? And our topic that you're going to see in this paragraph is if or how or when the U.S. might have jurisdiction over foreign countries. So I'm going to give you now this paragraph, and I'm going to give you 2 minutes to read it. If you don't want to read it, you have 2 minutes to get a cup of coffee or stand up and stretch, right? And we're going to take 2 minutes to read the paragraph and try to decide which of the genres it is coming from.
Mm-hmm. Okay, thank you, everyone. And while we are giving the time for our readers to read, I have quite a lot of comments, Heather, that I wanted to share with you, getting back to the questions that you answer. So while the others are reading, so it's very interesting to answer your questions that are, who are the readers and whether the document should be reader-friendly. So, for example, Anna says that she has never heard before that a document should be reader-friendly or the purpose or the focus is on the reader. So usually the legal document, the reader is another lawyer. And that is very interesting because we have a lot of disagreement among our participants, which is great and which is standard because they are lawyers, and lawyers always have our different opinions. So, and that's why, for example, speaking about responsibility, some of our participants say that, Yelena, she says that I have responsibility to the reader of my legal text as a lawyer. Or, for example, that the reader is the person who uses and applies our writing. Or, for example, our reader needs to understand the legal text, even if he or she is not a lawyer. And Maya sums up it wonderfully, saying that one of the key factors in answering all three questions is exactly who we mean by the reader. And that's exactly what, Heather, you have just been saying. Is it a client, a non-lawyer? Is it a lawyer? And so on. And if we speak about the second situation, adds Maya, is that we remain more on the writer's side just because our reader is another writer in brackets. So there are a lot of very interesting thoughts. So, and we already start having the answers. So Natalia thinks that this is from appellate brief. Are quite a lot of, and there are some people who support her, like Ekaterina. And the bigger amount, the larger amount of our participants, Yulia, Varvara, Maria, Anna, Nikita, they all assume that it's a memo.
Okay. Well, they are struggling with the two items that I hoped that they would struggle with. And what we actually have here is an excerpt from an office memo. Mm-hmm. It has predictive language in it. So if you look at the last sentence, the courts in the United States would likely exercise jurisdiction over Urbania in this matter. That is a piece of language that helps to establish that the purpose of this particular excerpt is to predict an outcome, rather than to convince the reader of an outcome. It's a prediction. It's a fine distinction, though, that can be made, and we're going to explore that distinction more fully throughout our 6th series webinar. Let's go on and give you a second test, all right? So same situation, I'm going to give you a paragraph, give you a chance to see what your reaction is. I have changed the topic. This topic is about pets and pet ownership, right? So no more Urbania. Now we're talking about pets. And the legal topic here is if or how laws of the U.S. offer protection to pet owners whose pets are injured or killed due to the actions of others. So in the world of pets, here is our paragraph, and I will give you 60 seconds. I'm going to make you read this one fast. It's a pretty easy paragraph. So 60 seconds to read and vote.
Mm-hmm. Okay. All right. And while we are reading, can you please explain if it's possible, what does it mean, punitive damages? Because to some of our readers, some are familiar, but to some it may not be clear, just because we have not only lawyers who are watching us, but also there may be some interpreters or teachers of legal English.
So punitive damages in the U.S. context basically means like money. Mm-hmm. Like, can they be monetarily compensated for the damages to whatever, or the injuries to whatever the property is? So there are extensive property laws in the U.S. legal system. And so what is at issue here is the extent to which the property laws apply in situations where the injury has been to the specific type of property of a pet.
Mm-hmm. Okay, Thank you very much. And now we have basically our two options. So major part of our viewers, author Nadezhda, Nikita, Darya, Dmitry, many, Natalia, Natalie, they all think that it's our law review article. There are a couple of people who think that it might be an appellate brief.
Right. And they're both picking up on the persuasion component. In this situation, we have a paragraph that is trying to persuade, but the people that it's trying to persuade, the audience that's trying to be persuaded here, is not the court, as it would be if it were an appellate brief, but it is, in fact, from a law review article. So it's positing a new theory for how these types of claims should be treated in the legal system, rather than arguing for one particular legal case in a court at a particular time. Okay, we have only about 8 minutes left, but that gives me enough time to give you another quiz. This time we're going to quiz on organizational features. So when we think about how genre helps us understand the organizational features of legal text, instead of talking about what the text is doing, we're going to talk about what the text looks like, what the moves of the genre are, and how writers signal that organization, signal the moves to the readers. So we're going to take a look at two more simple texts here, and we're going to focus on headings. So headings are only one of many different types of organizational features for genres. And it is a way that you can break up long texts into smaller groups of text. And the reason why it is an organizational feature is it helps the reader understand the way in which you are presenting your logic as a writer. So a common way that we see headings appear is through like the Roman numerals 1 and 2, subdivided and even further subdivided. And there are many other ways that can happen, but that's just one of the ways. And now we'll have our little quiz to see what your intuition tells you about two contrasting organizational choices for organizing long texts. And this is using headings, okay? So we're going to take a look at our third excerpt. This time it is coming from a software development company. And the legal topic for the software development company, software development company and retail company. The legal topic here is if or what the obligations of the companies are. And so here is our example text. And based only on looking at the headings, what text type is it? I'm not even going to give you time to read it. Just based on the visual way in which it appears, what is the genre?
Mm-hmm. Okay.
In the U.S., a song called the Jeopardy song. Da, 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 da.
Yeah, and we start having numerous answers. That is a contract. Everyone is, we have...
Is a contract. Okay. Now, contrast that contract and the way its organization is signaled with the next excerpt. And this one is going to be kind of easy because you have seen this one before, so I'm not going to give you the scenario again. I'm going to see if, based on what it looks like, and from taking a moment to read some of the key words that you see, what genre do you think this organizational strategy fits?
And I wanted to add that while we're waiting for our participants to read, I just wanted to add, which is kind of suddenly out of nowhere, that we are extremely happy that we have our Dr. Heather Werger with us, because she is a renowned legal English specialist from Washington, D.C. She's an associate professor at one of the universities there, and that's exactly her specialty, teaching legal writing as a linguist. So really the deep understanding of legal texts. And it's very, very interesting to see the how different, well, different from us, you, Heather, present the information. You give us a lot of room for thought. Thank you very much. And everyone says that it's law review article.
And everyone is right. This is from a law review article. But this type of organizational strategy, in fact, both the contract and the law review article examples, those organizational strategies can appear in other of the legal genres. So it's not really always an either or, it's that they work together. When we look at our final category, and you'll be happy to know I'm not going to quiz you anymore today, right? But when we look at the final category of language features, we then move into what does the text sound like, and how do writers use words, choose words to convey their voice, their sound, as they express their logic and their organization to readers. So as we work through the upcoming weeks, we will have a chance to take a look at expected language patterns that show the logic features and that show the organization features. So I do hope that you will join us in future webinar sessions as we dig into all of these issues more deeply. What I'm going to leave you with today, because I know we're running short on time, is I would like to leave you with my sort of final thoughts about why I began with the reader. So I'm ending the way I started. And research tells us that the reader is the driving force behind the writing. The writer is choosing particular ways of writing to serve the purpose of writing for a particular reader. The way I like to phrase this is that legal writing is effective when it meets the expectations of readers. But depending on who those readers are, those expectations are going to differ quite a lot, right? Writing is a choice-based endeavor. It is personal, but when you are writing, especially in the legal profession, you are writing for a reader, and that means your choices are being translated through a social context. And when you fulfill the expectations of that social context, then your writing is going to be deemed effective by your readers. That brings us to the end of this first webinar, and if you choose to join us on October 22nd, we will take a look at how legal English writers integrate law into written text through the eyes of a linguist.
Mm-hmm. Thank you, Raj, Heather, and we would like to thank everyone who has been watching for us today. And right now we're done with our theoretical part, and those of you who have signed up for a practical session, it's time for us to join a Zoom link that was provided to you, because we're now going to start a second part of our class, which we do have limited spaces are available to participants. And for now, we're going somehow with Heather to try to manipulate and deal with 100 participants in one Zoom session. It will be a new challenge for us, but we like challenges. So, and yeah, so okay, so everyone, we are finishing up and wrapping up our live session, and we're getting to the practical part. And for everyone, see you on the 22nd of October. Thank you very much, and goodbye.